On the 12th of August 2016, you'll have to consider how the Insurance Act affects insurance policy claims. This video provides an overview of how the Act deals with a breach of a warranty in a policy. Before you watch this video, you should download a copy of our distinctive booklet on the Act, so that you can refer to it while watching the video. You'll find a link to the booklet on the page where you found this tutorial. You should also watch the first video in this series that gives an introduction to the Act and explains how the booklet works. I'm not going to cover that in this video, so make sure you watch that before you get any further. Let's get started. Page 17 of the booklet presents a visual overview of how I recommend you approach a possible warranty breach in an insurance policy governed by the Act. I'm going to lead you through this chart explaining each step that needs to be considered when you have a claim and where you think the Act might apply. The Act applies to both consumer and non-consumer policies where a breach of a warranty is concerned. You start with a key question: when did the policy incept or renew? For the Act to apply, it must be on or after the 12th of August 2016. This is slightly different to the way in which the Act deals with non-disclosure. Even where there has been a variation, a breach of warranty will fall under the scope of the old law if the policy incepted or renewed before the 12th of August 2016. If you answer no to this, then you should deal with the claim applying the law as it was before the Act came into force. If you answer yes to that question, so the policy did incept or renew on or after the 12th of August 2016, then move down the page following the yes arrow. There is in fact some overlap between the Insurance Act and the Consumer Insurance Disclosure and Representations Act 2012, and the chart references both pieces of legislation were appropriate, as it does here. This box is a reminder that certain representations cannot be turned into warranties by a policy's term. That means what were once called basis of contract clauses are no longer effective. Such terms try to turn every representation into a warranty. They heavily favour the insurer, and they have been done away with. This brings us to an important group of questions. A key provision of the Act allows insurers to contract out of its provisions. You should therefore check whether you are looking at a policy that states the Act does not apply. If you have a policy with such a term, then you need to follow the yes arrow right, where you will see there's a blue box. This question requires you to work through another page before you have your answer. You'll need to turn to page 23 of the booklet, which will help you to assess whether the insurer has successfully contracted out the Act. If you do that, then once you have followed the chart on page 23, you will have your yes or no answer as to whether the insurer has successfully contracted out of the Act. If they have contracted out, then follow the yes arrow, and you'll see that you now need to consider the claim in relation to the policy's terms. That's outside the scope of this booklet. However, if the insurer has not contracted out the Act in relation to warranties, successfully or at all, then follow the no arrow down to the next question. This question is really a reminder for those handlers dealing with fraud claims. Where there is fraud but also suspicion that there has been a warranty breach, handlers can choose how best to approach the claim. The question asking if the claim is fraudulent is obviously a complex one and way beyond the scope of this guide. But if you've established that there is fraud, or think you might, then follow the yes arrow to the right. You'll see the blue box that you should turn to page 27 to see how the Act has codified the remedies available to insurers. But if fraud is not involved, or there is fraud and you want to see how an alternative approach might work, then follow the no arrow down. You now have three situations that take a breach of warranty outside the scope of the Act. If you answer yes to any one of these three questions, then the Act no longer applies. Let's quickly look at each of these in turn. Have the circumstances changed that the warranty that has been breached no longer applies? So what might those type of circumstances be? Well, here's an example. Say you had a property policy and the schedule to the property lists a number of buildings. There's an alarm warranty that requires a monitored alarm to be maintained for each of those buildings. Now, what if one of the properties was sold so the insured no longer had any control over the relevant building, but the warranty still said that the property's alarm had to be monitored? If it was not, and there was a claim in relation to one of the other properties, then technically a warranty has been breached. Now clearly that's unfair. That therefore codifies the rule that where there's been a change like that, then the warranty no longer applies. Next we have a situation that would mean compliance with the warranty is now unlawful. That's going to be more straightforward, and such situations should be more obvious to you. They're going to be few and far between. Finally, of the three specific situations, an insurer cannot rely on a breach if they have waived their right to do so. That will usually be by a representation that they're not going to rely on it. There should not be any need for the insurer to have changed their position in reliance of the insurer's representation. As I said earlier, if any of these three situations are present, and you've answered yes to any of the three questions, then the insurer cannot rely on the warranty breach. Otherwise, you'll have answered no each time. You'll then move on to the two most important changes brought about by the Act in relation to breaches of terms. Now, to quickly summarise, the Act requires that there be some connection between the warranty breach and the loss. The breach does not have to be causative of the actual loss. Also, breach can now be remedied, something that the old law did not permit. As soon as there was a breach of the warranty under the old law, then the insurer was discharged from their liability. More often than not, you will not need to understand precisely how the Act brings about these changes, but if you do need to understand the detail, look for my other videos on these two parts of the legislation. They'll take you through pages 19 and 21 of the booklet. What I will do now is give an overview of these two important changes. Now, I haven't really referred to individually to section numbers of the Act so far, but I will here because section 11 is likely to cause problems in the future. I think you're going to hear commentators talking about section 11 and the issues that arise. Here are the key things to remember. The old law does not require there to be any connection between a breach of a warranty and a claim on the part of the policy that the warranty relates to. So, if a warranty in relation to, say, the disposal of trade waste every day was breached, then the insurer was discharged from their liability immediately and automatically. If there was then a fire that was, say, caused by arson, then the insurer could rely on the waste warranty breach to deny the arson claim. That position has now changed. Well, sort of. The Act requires more of a connection between the breach and the loss. But that doesn't mean insurers have to show that the breach warranty caused the actual loss. Rather, Section 11 provides the insured with ammunition to argue that their insurer if a warranty breach is relied on. If the insured can prove that the warranty was not intended to reduce the risk of loss of the type suffered in their claim, then the insurer cannot rely on the breach. So, a warranty might require premises to be secured each night, and an insured might fail to do so when they leave the front door unlocked. A warranty has therefore been breached. So what if there was a burglary? An insurer can rely on that warranty breach even though a burglar might have accessed the building in a different way, say by breaking a window. The warranty was intended to reduce the risk of theft, and even though the breach did not cause the loss, it is connected to the type of loss that was suffered. If the breach is not relevant to the loss, then you must move down to the red oval. The insurer cannot then rely on the breach. It is thought this clause will cause a few disputes in the first few years of the Act's enactment. I covered in more detail in another video. One final thought on Section 11. There were suggestions that this section might not be limited to warranties but might apply to condition precedent or even exclusion clauses. I discuss that further in the video devoted to Section 11. The key change to the existing law brought about by the Act means that an insured is now able to remedy a breach of warranty. As with Section 11, I'll cover more detail on this on page 21 in another video, but now you just need to know the following. If the insured breaches the warranty and then remedies that breach before the loss occurs, then the warranty will not bite and the policy will pay out. Sometimes, of course, the damage can take some time to develop after the cause of the loss has occurred. The thing that the warranty was meant to prevent may be a set of circumstances that might increase the risk. In that case, the warranty breach has to be remedied before the occurrence of the cause of the loss. It is not enough that the breach is remedied before the loss materialises. Now here's a classic example. Say a warranty prevents a ship from entering a war zone, but the captain takes it into the war zone anyway, with the result that the ship is torpedoed. The breach is remedied when the ship leaves the war zone, but it might sink sometime after that. The fact that the breach was remedied before the loss of the ship does not stop the insurer from relying on the warranty breach. It is the timing of the occurrence of the circumstance that is important here, not the timing of the actual loss. Really, you're looking to see if the cause of the loss occurred before the warranty breach or after the breach was remedied. If the cause of the loss was before the warranty breach was remedied, then the warranty still bites and there will be no cover. I'll give further consideration to the detail of this part of the Act in a separate video. So there you have it. The approach to warranty breaches is one of the key changes brought about by the Act. This has only been an overview of the changes to breach of warranty. You can watch other videos in this series to learn more about the detail of the Act. I'm Michael Hogg, a partner in Kendies London office. Insurance Act 2015, a distinctive approach.